Welcome to the Law Report. Today I have a very short episode here. For you, I was recently asked if for the purposes of burglary, if someone breaks into a container, if the person who breaks into the container can be charged for burglary, and if a container for the purposes of burglary falls within the Theft Act of the Turks and Caicos Islands. And my short answer to that is categorically a yes. And I'll be back shortly to discuss. But before I do, my usual disclaimer: this is not legal advice, should not be taken as such. For legal advice, please contact an attorney of your choice.
You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to speak to an attorney and to have an attorney present during any questioning. If you cannot afford a lawyer, one will be provided for.
Welcome back. So in my view, a person breaking into a container can be charged for burglary, but it would depends on what the container is used for. Now, under the Theft Act of the Turks and Caicos Islands, Section 11, which deals with burglary, it sets out that a person who enters a building, a part of a building as a trespasser, and would intend to commit any such offence as is mentioned in subsection 2, or having entered any building or part of a building as a trespasser, he steals or attempts to steal anything in the building or part of it, or inflicts or attempts to inflict on any person therein any grievous bodily harm. Subsection 2, the offences referred to in subsection 1A are offences of stealing anything in the building or part of the building in question, of inflicting on any person therein any grievous bodily harm, or assaulting any woman therein, and of doing unlawful damage to the building or anything therein. Subsection 3 states that references to subsection 1 and 2 to building shall apply also to an inhabited vehicle or vessel, and shall apply to any such vehicle or vessel at times when the person having a habitation in it is not there, as well as times when he is. And a person guilty of burglary upon conviction and indictment shall be liable to a term of imprisonment for 14 years. So the question that naturally arises is if a container can properly be classified as building for the purposes of Section 11 of the Theft Act. Section 3 made no reference or no specific reference to container. And the question to be answered: when does a container falls within the classification of a building, a part of a building? In my respectful submission, if a container is used as a dwelling, as an office, or for storage in law, it is classified as a building. In the case of B and S versus Leathley 1979, a lorry container was resting on sleepers and used as refrigeration storage. It was connected to the electricity power and had been in the same place for 2 to 3 years, and the court held that the container did constitute a building for the purposes of the Theft Act of 1968. The Theft Act of 1968 in England and Wales is identical to the Theft Act of the Turks and Caicos Islands. What are the facts? Or what were the facts? In that case, the defendants, B&S, had entered the freezer container, which was placed in a farmyard, and stole goods from the container. The container was resting on sleepers. It weighed about 3 tons and was about 20 to 25 foot long. It had not been moved for over 2 years. It had doors, locks, and was connected to the main electricity supply. The defendants were charged with burglary, and they were convicted and subsequently appealed their conviction. So, what were the issues? In that case, the issues were whether the trailer or the container, for the purposes of the Theft Act of 1968, which is identical to the Theft Act in the Turks and Caicos Islands, whether that container constituted building. Now, the court, following the decision in the case of Stevens and Gorey of 1859, which predated the 1968 Theft Act, in which it was held that a building was a structure of considerable size and intended to be permanent, or at least to endure for a considerable time. The container, the court held, fulfilled this criteria, as it was likely to remain there for the foreseeable future. Therefore, it was a building for the purposes of the Theft Act of 1968. Consequently, the defendant's appeal was rejected. And there you have it, folks. A container, when used as a dwelling, an office, a storage, it has been at one place for a fixed amount of time. If someone enters that container as a trespasser, they steal from that container, they inflict any grievous bodily harm, and that person, the assaulting woman in that container, then that container, for the purpose of the Theft Act, is a building, and that person is liable to be convicted for the offense of burglary. Now, I would just like to mention one other thing. The Act states that a person enters a building or part of a building. So if a person enters the porch or the balcony of someone's home, even though that area could be considered an open area, that person also commits burglary. If the doors are wide open to a house and someone enters as a trespasser, he commits burglary, because we tend to believe when the word of burglary is mentioned that they have to be picking of locks, breaking down of doors, climbing through windows, etc. No. There are even cases where you could invite someone into your home, probably into the dining room, the kitchen, etc., And if they had no permission to go into the bedroom or some other part of the house, that could be considered as burglary. There you have it, folks. Thank you for watching, and I will see you shortly in my next video. I say cheers and bye for now.